following constituencies. That's a matter of record, so you'll get it. At the close of the poll on 7th December, polling station results were declared in all the above constituencies, and the election process advanced to collation of results at the constituency level in order for the winner of the parliamentary election to be determined and declared. In the case of 4 of these constituencies, the applicants contend that the collation exercise had completed and then the parliamentary electoral results were declared in their favor. In the processes before us, the 1st to 7th interested parties contend that the collation of results was not completed in those constituencies. It was in this state of affairs that the 2nd to 7th interested parties filed series of applications in the High Court and prayed for orders of mandamus against the Electoral Commission, which is the first interested party herein. Their prayers were for the High Court to order the Electoral Commission to undertake collation of in their constituencies and to make a declaration of the winner of the constituency election. In the meantime, the applicants herein had earlier on 16th December 2024 filed an application for judicial review against the Electoral Commission, in their case praying for declarations that there had been earlier declarations in their respective constituencies and praying for injunction to restrain the Electoral Commission from doing another collation. On 20th December 2024, the 2 applications were listed before the trial High Court judge for hearing. The first application called by the trial judge was that for mandamus by the interested parties herein. The Electoral Commission did not file an affidavit in opposition and stated in court that they were not opposed to the application for mandamus. However, Mr. Godwin Eduji Tamaklo of counsel for the applicants hearing stood up in court and informed the High Court judge that his clients were interested in the mandamus application and that they had even filed a motion to be allowed to join the mandamus case. The judge decided to proceed with the determination of the mandamus application and granted all of them in favor of the applicants therein. It is those rulings dated 20th December 2024 that the applicants have invited this court to quash and to prohibit the trial judge from having anything to do with the applications. The grounds of the applications were as follows. I've listed them in accordance with the motion paper. The interested parties filed affidavits in opposition with exhibits as well as statements of case in which they argued in answer to the case of the applicants. Before the courts could hear the application, counsel for the 2nd to 7th interested party raised a preliminary objection and pointed out that the rules require that at the filing of the application for certiorari, the ruling which is sought to be quashed should be attached, but that was not done. The court indicated that the application should proceed and that in the final ruling would answer the charge. Our conclusion was informed by the fact that there was an explanation in the affidavit as to why the ruling was not attached. And we took note of the fact that now the rulings are before the court and in order to determine the merits of the applications, which have been well argued by both sides, it was in the interest of justice to proceed. So we proceeded. Counsel for the applicants first stated that since at the hearing on 20th December 2024, the trial judge was notified that the suit to be affected by the proceedings for mandamus, the judge ought to have joined them to the case in order that they could file affidavit in opposition to the grant of the mandamus. He further submitted that since their application filed on 16 December 2024 was listed before the judge for hearing the same day, the judge had knowledge of their contentions that collation had already been completed and declarations made in 4 of the constituencies. So he ought to have permitted them to put that evidence before him in respect of the mandamus application. Additionally, the applicant stated that the procedure rules on judicial review in the High Court, which were applicable in the case of the application for mandamus, being Order 55 of the High Court Civil Procedure Rule CR 47, made ample provisions for interested parties to be added to an application for judicial review, but the trial judge failed to apply these provisions and to add them. Counsel for the applicants relied on a number of decided cases, especially Republic versus High Court Bolgatanga, ex parte Hawa Yakubu, 2001-2002, Supreme Court of Ghana Law Report. Counsel for the applicants further stated that the trial judge exhibited bias against the applicants by not only failing to admit them into the mandamus application, but by opting to hear the mandamus application first when their application for declarations and injunctions was filed earlier in time. In answer, lawyer for the first interested party relied on the statement of case he filed and added that he observed that none of the individual parliamentary contestants had an affidavit before the court in which they complained about any miscarriage of justice. Lawyer for the second interested party, the second to seventh interested parties, stated that he was vehemently opposed to the application. He pointed out that the applicants built their case on the failure of the trial judge to join them to the mandamus application. But he submitted that the rules of the court on non-joinder of a party is to the effect that non-joinder does not vitiate proceedings. He referred the court to the case of Bobier versus 21st Century Company Limited. He submits that the judge had a discretion given to him in the application for judicial review to join interested parties if it was in his opinion. If it was in his opinion that they would be affected by the proceedings. The trial judge did not consider the applicants necessary parties and he exercised his discretion against joining them. He submits that such order would not be granted to quash the exercise of discretion by a trial judge. He referred to the case of Republic versus High Court, the Republic versus Court of Appeal, ex parte Chachichikata, 2005-2006 Supreme Court of Ghana Law Report. Now, the consideration. In our opinion, the crux of this application is whether, under the circumstances that the trial judge was faced with, could he have proceeded to determine the mandamus applications without hearing the applicants in the form of affidavit evidence and legal submissions on whether the case before him, notwithstanding non-opposition by the Electoral Commission, was a proper case for the grant of an order of mandamus. it is very clear to us that it was plain to the trial judge that the clients of Mr. Godwin Edwige Temaklo stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally, and Order 55 on judicial review. In the case of Awuni versus West Africa Exams Council 2003-2004, Supreme Court of Ghana Law Report, the Supreme Court quashed a decision of an administrative body, that is the West Africa Examination Council, for failure to accord persons a right to a hearing. The statute under which the West Africa Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West Africa Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. The interested parties say that because Mr. Godwin Edwige Temaklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabikwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Hafuanon North are not affected by this order, by this our order, and in effect, those declarations stand. Despite questioning the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statements of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed, yeah. Now those which have been quashed, sorry. Those which have been quashed, yes. To file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for a hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court, ex parte, Ajua Company Limited, Auditor General Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
My lords, we are extremely grateful, extremely grateful.
We are grateful to the court. My lords, you are grateful. My Lord, there's a second motion on your docket.
Respectfully, my lords, civil motion number JA/30/2025. The Republic versus High Court General Jurisdiction 13, Accra. Ex parte, the National Democratic Congress. National Democratic Congress. Baba Sadiq. Erabna Oben. Amenope Philibert Fumi. E.B. Bright. Christopher Bayer. Akwesi Edusei. The Electoral Commission of Ghana. Patrick Yalbuama. Nana Ekia Owusu Efriye. Frank Ano Domper. Charles Forson. Martin Kweku Ejay Mensah. Eric Nana Ajiman Efriye. Inspector General of Police. Respectfully, my lord. That is so.
My lord, that is so. The same time. And the same representation.
Council, the same representation, Council.
That is all, my lords.
Okay.
Let's replace that person with Nana Befi Yeboah. Nana Befi Yeboah. He will replace Nana Ejay Bafo Awua. Nana Ejay Bafo Awua.
Nana
Ejay Ajye. Bafo.
okay, no.
Bafo Awua.
Yes.
Awua.
The lawyer,
Yeah, he's a lawyer.
yes, and then now MP.
Yes.
MP elect.
MP elect, yeah. Well, for the 2nd to 7th interested parties.
So, Bafo has been replaced by Nana
Befi Yeboah. Malos Befi, BAAFI, and then Yeboah.
Okay. Thank you. So, what is the fate of this application?
My lord, in view of the fact that the orders we're seeking to stay have been quashed, we will seek leave of this court to have the application withdrawn.
Yes, Mr. Menugo. Any opposition?
No, my lord.
Mr. Nimako?
My lord's no objection.
There be no opposition, no objection to the prayer of the council for the applicants. The application for stay of execution is struck out as withdrawn.
Extremely grateful.
To give me some little cost.
No comment.
I think when you finish the whole thing, when you finish the whole matter.
The whole matter.
Yes. Yeah. Yes, Inspector General of Police is present. I think you are here. So you are being moved into all of this. You notice that you didn't find any processes. And it's understandable because your role is very crucial. The role of the police is very crucial. You see what this application has done. During the application that we should rescue those we all have to come. We decided that instead of adjourning for a judgment or to give you a ruling without reasons, in order to forestall any unnecessary comments and therefore disruptions, that is why we constrained ourselves and did this. So also play your role as a convey to IGP, you play your role. Neutral persons, and then make sure that we avoid situations which can lead to an escalation of any disruptions. Okay? Okay. Now the political parties, they are not here. There is the lawyers who are. At least there's a general secretary here, Mr. Fifi Kwete. Yes. Yes. We also think, as we are talking to the police, make their work easier. You, the political parties, make their work easier. Try and then also help so that we have a peaceful atmosphere at the board. Thank you.
All rise.
I'm taking a picture with you. Yes, like the man. Oh, hey, Basti too. The boy is here.
So you're still watching live proceedings from the Supreme Court of Ghana, and they have just given a ruling on the order that was sent to them, or the writ that was filed at the Supreme Court by the NDC. And after about 3 hours of a break, the judges, the 5-panel judge led by Justice Gabriel Puamang, have returned with a judgment, and their judgment finally is that the recollation of a number of constituencies have been set aside. Out of the 7 constituencies that were declared in favor of the NPP a few days ago by the Electoral Commission, the recollation exercise, the Supreme Court have, by unanimous decision, giving an order quashing 4 of those constituencies, leaving 2. So the constituencies that the Supreme Court has quashed, meaning they have cancelled out the results that were declared by the Electoral Commission, the 4 are Okaikwe Central, Ablekuma North, Tema Central, and Techiman South. These constituencies were part of an original 9 that were under contention. And out of that 9, you remember that 7 of them were declared in favor of the NPP. So the NDC actually went to court before even the declaration that the Supreme Court's decision, I beg your pardon, the High Court's decision to say that these constituencies' results need to be recollated for another declaration. Well, the Supreme Court says that a number of infractions happened during that entire process, and because of that, these 4 constituencies have been quashed, and the current results that were given by the Electoral Commission are null and void and of no effect, so they do not stand. And those constituencies are Okaikwe Central, Ablekuma North, Tema Central, and Techiman South. These are the 4 that the Supreme Court has trashed out. However, they have upheld 2 constituency results that were also done under the same process. These constituencies are Nsawam Adoejiri and Ahafua North. Nsawam Adoejiri and Ahafua North. These 2 constituency results have been upheld by the Supreme Court, and they are clearly giving indications that, well, based on a number of factors they considered, they believe that these 2 constituencies actually, applied all the necessary processes and came to a final result, which have now gone in the favor of the candidates that have been declared winners. So the EC actually, per the dictates of the Supreme Court, went through the entire process, or used every available means to make sure that the process was free, fair, and accurate in favor of everybody that, or all the stakeholders that took part in it. So 2 of them, which is Nsawam Adoejiri and Ahafua North, are actually have been upheld. So let's go back to the court and listen to some interactions of some of the candidates that are also in the court today.
I think it's important that everybody understands that this is just the beginning of our work. And I think that this experience equips us to be able to represent all our people a lot better. So we're very grateful and for the opportunity. And also we want to say hello to Ghanaians and our constituents. Merry Christmas, Happy New Year. Thank you.
She's here.
Well, I think it's a good day for country. The whole world is watching, not just Ghana. So I think it's just the beginning of coming together as one people. And then I think it redeems the image to an extent of our courts and our judges. So it's all well and good. All well and good. Thank you. Thank you.
So essentially, the Supreme Court has ordered that the NDC's application should be reheard by the High Court, because the 5 panel of justices chaired by Justice Gabriel Puamang indicated that the least the court should have done was to give a hearing to that joinder application filed by the NDC, which they refused to do so. Now, there's been an order for an abridgment of time, meaning that on Tuesday, December 31, the court will hear this mandamus application by the NDC. So as it stands now, the High Court's initial decision has been quashed. However, two outstanding constituencies, which is the Nsawam Aduajiri and then Ahafo Ano North, that decision still holds because essentially their collation and then declaration was not yet done, and so their High Court's decision, which made them complete the processes, will now hold. We'll see how things will pan out from then onwards. There was also another application for stay of execution, which was at this point had become irrelevant or moot, and so the director of legal of the NDC, Godwin Eduji Tamaklu, withdrew that application, and that was the second application that you had the court considering. We'll see how the coming days will look like, since there's still a little more to be done on this matter. Back to you in the studios, Lord Idwasari, TV3 News, Supreme Court.
Before you go, and we're grateful that you could at least follow through proceedings for us. So Lord Idwasari is our man in court, and we'll try and pick the thoughts of some of the key actors in that court. The ruling was a few minutes ago where the Supreme Court, let me just run that by you quickly if you're just joining us. Out of the 7 that had been declared by the Electoral Commission after recollation, the Supreme Court has quashed 4 of them and upheld 2. Now, the 4 that they have quashed are Okaikwe Central, Ablekuma North, Tema Central, and Techiman South. And there are 2 of them that have been upheld, which is Nsawam Aduajiri and Ahafo North. Kojoga Daudu is one of the legal members of the NDC. Let's listen to him.
High Court judge, was hearing the mandamus application, had noticed that the applicants, that is the candidates for Okaikwe, Tema Central, and others, they had filed, and the judge was put on notice that we had an interest. They had filed this earlier, but did not do. So the court says that they had notice, and once you had notice, you should have heard them. You should have joined them and heard them, notwithstanding the fact that the rules that they are talking about, because hearing somebody, natural justice has become a constitutional level. It's been elevated to constitutional right. So even if administrative bodies, where they use the WAEC example, Awuni versus WAEC, that if they are bound to give a hearing notice to somebody who has an interest, then how much more a court, High Court, that will not listen. So that's why they gave the decision that whilst there was evidence that those had been declared already or something, they should go back. And that's why they've abridged the time. Let the court allow them to file the affidavit, then they can make an argument, they can be heard. Legal argument can be heard, whether the mandamus should be granted or not. But to also, that there should be some fairness and impartiality, because already there is some kind of likelihood of bias they are talking about the judge. So it should be sent to another judge for the matter to be heard. So all the processes have been that it should be ready before the 31st, and the 31st we have to go to court to hear that matter.
Does this tentatively mean that, as it stands, the MP-elects of these 4 areas are still MP-elects till maybe Tuesday? Is that what it means?
Yeah, yes, that's what it means. So we have to go. Then once they go, that's why it says that for Nsawam and Ahafo Ano, it was a collation that was incomplete, and they have done it. So that's why those results will stand. But for the other 4, they have to go back to the High Court, and the High Court will now hear the application.
All right, thank you very much. That was Victor Adaudu, one of the lawyers of the NDC. We'll still be getting more reactions from the various quarters. I see Gary Nimako. Let's get Gary speaking. We're going to get his thoughts. He's speaking for the NPP.
All right. The EC did collation and declaration in the affected areas. NDC said they were not heard on the application. They came to court to say that they were not heard. The court said it's a fundamental rule to be heard. So go back to the court and have your matter heard. So it's simplicity. We are going back on Tuesday. They will file their response. Okay, on why they think that there was collation or there was no collation. The court will hear the matter, make an order for EC to go and make collation in the declaration. That is the point. So it's not about recollation. So this word recollation, there is no collation at all.
Finally, some jury and the other one have one also.
Yes.
If the NDC decides to contest that again on a separate platform,
well, that is up to them. The court has spoken already, so that ends the matter.
Are you face them?
Face who? We are not fighting. They are brothers. We are not fighting. You saw me hugging them and talking to them. NDC, they are not enemies. We are not fighting. It's a question of the brains. We are not fighting.
The court is concerned about peace after today's ruling. What message do you have?
No, not after today's ruling per se. It's peace post-elections. You realize that after these elections, there have been a lot of post-election violence. We don't understand. There must be peace in the country. If we won elections, what about the destruction of state properties and all these things? It's not good. So let's all learn to abide by rule of law. That is the way I see it. That is all. So please, all parties, political parties, especially our brothers in the NDC, they should learn to respect the law. That is all.
So that was Gary Nimako. He's the lead counsel for the NPP side, essentially rehashing the fact that they'll be back in court on Tuesday when the court hears that mandamus application again by the NDC. They're basically saying that they should file all their documents and then they will face them as such. As it stands now, like we noted earlier.
Right. And so we just heard proceedings from the Supreme Court, and Lord Eduasare is our man who's following developments there at the courts, trying to pick the thoughts of some of the key actors there. I just heard from Gary Nimako, who is lawyer he was a legal counsel for the NPP representatives in court. And so if you're just joining us, this is your Election Command Center. News just coming in from the Supreme Court indicates that 4 out of the 7 declared constituency results after recollation by the EC have been quashed by the Supreme Court. And the bottom line is that, well, to cut a long story short, what has happened in the last few days, the Supreme Court is saying that there was a rule of natural justice that was breached. So maybe for clarity, when the back and forth was going on as regards these 9 outstanding constituencies, the case was sent to court. And when it went to the High Court immediately said that there should be a recollation exercise of the 9 outstanding constituencies. So they actually gathered at a particular place under the supervision of heavy security led by the EC to try and recollate these results of the 9. Out of the 9, after the recollation, 7 of them were declared in favor of the NPP, 2 outstanding. Now, the Supreme Court has said that at the time that the case was at the High Court, when the NPP had taken the case to the High Court, NDC had also filed to join the case. But the court, the High Court at the time, did not hear the NDC, which is the breach of the rule of natural justice, which indirectly says when someone says, I'm interested in a particular case, and the person actually goes through the process of filing, you are by law expected to give the person a hearing. And because the High Court failed to do that, and thereafter a recollation and declaration has been done, the 4 that were declared after the recollation, the Supreme Court says we are cancelling all of those results out, which indirectly means that those who had won earlier still stand. Those results still stand. In a jiffy, my colleague will be speaking to Godwin Eduji Tamaklo, who is the lead counsel for the NDC in court a few minutes ago. So we'll come back. So if he does get him, we'll pick his thoughts briefly to understand what he makes of today's ruling. However, back to the key issue, the Supreme Court has now given a different directive, which is that although they have quashed the 4, the case should be sent to another High Court. Now, the NDC also found that the judge that was sitting on the issue in the first place, the first High Court, they accused the judge of being biased. So the Supreme Court has said that they are taking the case to a different court, and we are hoping that to bring further clarity to this. So let's listen into that conversation from Edigi Tamaklo and my colleagues that will bring you details.
Comments on these.
I think we are grateful to the Apex Court. At least it has restored sanity in the process that was going on at the High Court. And that for us is why we are grateful to the Apex Court. And I want to thank my able co-counsels here, my seniors who accompanied us to court today for this one. At least fairness has been done today. And that is all that we're calling for. The fact that we have to go to the High Court, what strategies we are going to deploy, I will not disclose it. But I just want to thank everyone for this. And I'll urge our party supporters in Ahafano and Suhun to stay calm and watch what we'll be doing going forward.
Now, one thing that you sought to put across was the issue of bias, and that was not agreed by the Apex Court. You cited about 3 or 4 instances that the presiding judge what you described as bias.
No, I understand the policy rationale. I mean, making a definite finding of bias against a judge obviously is not an easy start, right? But we've made a point, to the point that the court itself agrees that he should not hear the matter again. It's enough rebuke of the entire process that he actually supervised. And that for us is significant, yes.
What word do you have for the constituents in these 4 areas?
No, I just, they should stay calm and we'll take it out from there. What's important is that all the coalitions, the declarations that happen, that are founded on those orders have all been set aside. Significant. I'll just end it here. Thank you.
Thank you very much, Edigi. So you heard Edigi Tamaklo, the lead counsel for the NDC, his initial comments on the decision of the Apex Court. He says he's pleased with that decision, although he sought to put across about what he reported as a biased nature of the presiding judge, Justice Agyemang. This was not agreed by the Apex Court. He says once the point has been made, especially because the Supreme Court agreed with prohibiting that judge in that regard, so they are pleased. They're saying they are waiting to go back to court on Tuesday to hear that mandamus application. Will put their best foot forward and see how things will pan out from there.
Right. Lord, thank you again. Certainly, I'm sure that you try and pick 1 or 2 other key individuals in there so we can get their understanding of what has gone on. But if you're just joining us, news coming in from the Supreme Court, and it's breaking news you can see on your screens at home. It is that the Supreme Court has ordered all the key actors out of the 9 constituencies that are standing to go back to the High Court for a hearing to begin. So there is a contention on a number of the constituencies, and out of those that have actually been recollated and declared, the Supreme Court says all that was a nullity, all that was, for lack of a better expression, a waste of everybody's time. Go back to another High Court, get a new judge, and then let the hearing begin, where all the key players in this particular case, we're talking about the NDC, the NPP, and the Electoral Commission. These are the 3 key stakeholders in the outstanding constituencies. They should all go to a different High Court for the process to begin, where they will all be listening in very keenly. It was on the back of an earlier High Court decision where the NDC, in making a submission to the Supreme Court, said that they had filed to join the case at the High Court. However, that High Court judge did not give them a hearing, for which reason they thought he was biased and was not doing the right thing according to law. So the Supreme Court says, based on that, let's go back to another High Court. A different judge will sit on the case. All the actors come and make your presentation for a final decision to be made, which indirectly means that of the 9 constituencies outstanding, proper hearing will begin on the 31st of December, which is coming Tuesday, 31st of December. So between now and then, all the actors have been asked to file their motions and their writs so that the High Court can quickly sit on the issue for us to get clarity and finality before the 6th of January, when the MPs will be sworn in. So it is not entirely over yet, especially for the 4 constituencies that have been quashed. I'm talking about Okaikwe Central, Ablekuma North, Tema Central, and Techiman South. The Supreme Court is saying that although they had earlier results in their favor, hold on to that. Let's go to the courts. Let everybody make their case. And then the High Court will give a final determination to that case. However, 2 of the constituencies, Nsawama Dwejiri and Ahafano North, their results are actually clean and given a good bill of health. So they are going to go through the process of registering and be sworn in on the 6th of January 2025. So stay with your election command center. I know there's a lot of legal terminologies flying all around, but simpliciter, the Supreme Court has given a new directive. So all the collation and declarations we saw have been thrown away by the Supreme Court. We will have that entire process started again on Tuesday, the 31st of December. So stay with your election command center, and we'll definitely be updating you. At 7 o'clock, we'll bring you better understanding of what has gone on at the Supreme Court today. And then later at 10 p.m. on Ghana Tonight, we'll give you even further clarity of what all of this means for our young and growing democracy. Thank you for watching your Election Command Center and staying with us here on TV3. Resuming regular programming, but definitely we'll be updating you on our various social media handles as and when any new development does come up. My name is Martin Esiedudate. Have a good afternoon and keep watching TV3.